This is us. Good morning, Your Honor.
Good morning, Your Honor. Omar C. on behalf of the defendant, Blanca Aguirre.
Daniel Curtis on behalf of the plaintiff.
Your Honor, we're here on our motion for a rehearing, a new trial in this matter. It took us quite a bit of time to figure out who would hear this matter. First, we brought in Fred Schumacher, and Schumacher punted it back to Your Honor because you were the trial judge on it. The usually is Schumacher. And obviously we had to set it before you because of the FTC protocol. This matter, we filed a motion for continuance of trial in this case before the trial took place on January 31st. We had it presented before Schumacher pursuant to FTC protocol. Schumacher indicated that this is something that needs to be determined by the trial judge. We presented this motion to Your Honor at trial. Your Honor determined that the trial needs to go forward and denied our motion to strike the trial order, and also denied our motion to defer this or to refer this matter to the complex foreclosure division. I'll say it quite simply, Your Honor. At the time, and I know that it was kind of chaotic when, as it always is down there during the trial calendar. I'm sorry. Right. So it was kind of chaotic when we were presenting Your Honor. We were actually trying to explain the circumstances giving rise to our motion, and Your Honor denied it and allowed the trial to proceed. I'll make it quite simple, Your Honor. I do believe, most respectfully, that Your Honor did not rule correctly with respect to determining whether or not this matter was at issue at the time of trial. It was clearly not at issue. We had a pending motion to strike the pleadings for fraud upon the court. We also had a motion
that was filed back in August of 2012.
That's correct. It was filed back in August of 2012. It was heard by Judge Schumacher in December of 2012. Judge Schumacher, after a very detailed presentation, determined, after looking at the document, that the signatures on the documents that we had attached to our motion did not appear to coincide with other signatures by the two same individuals. Set the matter for status and gave us an opportunity to conduct discovery. And there's where it gets kind of tricky. We spent nearly a year tracking down some of these individuals. When we finally found them, we finally served them, and after a lot of time and expense by our client to track these folks down, in Georgia, they hired two different law firms, one here and one in Georgia, to block our attempts to take their deposition. This is the depositions of known robo-signers. And we had several rounds of motions for protective orders, motions to compel, both here in Florida and in Georgia. So we did not sit in our laurels for a year and do nothing. I know that the court may feel, well, this was set back in 2012 and nothing has happened for you. Absolutely not. Your Honor can take a look at the docket. We can present, Your Honor, the docket of the Georgia case where you can see that there was activity nonstop to try to take these individuals. Eventually, we were able to take the deposition of one of these individuals about a week before the trial. We didn't get the transcript until about a day or two before the trial. So what the situation that we have is, after all this time and effort and expense, we have the evidence that we can present to the court, and the court, based solely on time that this matter has been pending, determined that all that evidence is not really relevant to what's going on here, and I can only presume that that's what the court determined, because it wasn't a very detailed order that was entered. But I would just make it clear to the court, Your Honor, I understand that Your Honor is under a lot of pressure to move these files along, to make these determinations, but we cannot, for 1 second, substitute.
Go ahead.
We cannot, for even 1 second, substitute our need to flush out these foreclosure dockets for the pursuit of due process. And in this particular case, we have a situation where the matter is clearly not an issue under Rule 1.440. The third DCA has made it very clear that this rule has to be strictly adhered to in reversing Judge Fierro, who decided to go forward with the trial on a separate matter. I can certainly present Your Honor with that case law that recently entered case. That's a Lopez versus U.S. Bank decision, Your Honor. And in that case, the third DCA reversed Judge Fierro on a matter that was clearly not an issue under Rule 1.440. The question here is, was the matter an issue or not? And then we look to the rule. The rule makes it very clear that if there's a pending pleading that has not been resolved, that's directed at the last pleading in the case, then this case is not an issue. And we look at, well, I'm reading directly from the rule, 1.440. I'm not reading from the Lopez case. The Lopez case basically says that if the matter is not at issue, it can't proceed, and it also indicates that we need to strictly adhere to that rule. We can't really interpret that rule. It is what it is. And then we look at not a recent case, but a case of Bennett versus Continental Chemicals, which I've also cited in my motion. And in that case, Your Honor, I underline the relevant sections. The only items that are excluded from the only matters that are excluded from the determination of whether or not it's not an issue are cross claims. We don't have a cross claim in this case. We have a pending motion to strike the pleading, which was never ruled upon by the division judge. It was never ruled upon because the division judge gave us an opportunity to conduct the necessary discovery. And we just obtained the necessary discovery after much effort, time, and expense about a week before the trial, and we were never able to bring that to the division judge. So what we would request from the court, Your Honor, is to strictly adhere to Rule 1.440, to determine that at the time of trial, based on the circumstances, it appears that this matter was not at issue. Vacate the final judgment, defer this matter back to the division judge for a ruling on that motion to strike, which is still pending. There's been no ruling on it. If we proceed to a sale in this case, we still have an issue. Either way, we still have a problem because at the time of trial, this matter was not an issue.
Good morning, Your Honor. Daniel Curtis on behalf of the plaintiff. It's very likely that right now what your experience is deja vu, because at trial this is identical to what we argued. We spent nearly 15 to 20 minutes arguing exactly this. Florida courts have been extremely clear that Florida Rule of Civil Procedure 1.530 should never, absolutely never be used to relitigate matters that were previously considered. It's only meant for matters where issues or certain things were overlooked or not considered when the trial occurred. That is not the case here. I could go through the entire transcript. Counsel raised as to every piece of evidence that was entered into evidence and to almost everything that came up at trial. He raised an objection using 1.440 as the basis for his objection. It's always been raised. Additionally, I think there's some confusion here. Well, first let me point to this. Administrative Memorandum CIV 12-E 24CA01 establishes requirements for residential mortgage foreclosure cases, and it clearly states that all motions must be promptly set for hearing upon filing. Upon filing, failure to set motions for hearing may result in these motions being deemed abandoned or denied without a hearing by the presiding judge. The day of trial, we spent nearly 15 or 20 minutes arguing this. Your Honor denied their motion for continuance based on the case not being at issue. Here we are today re-arguing this. There's a big difference between an appeal and between a motion for rehearing. They still have the ability, if they decide to do so, to appeal the ruling that Your Honor entered the date of trial. That is what they have to, that is the protection for error, I would say. This is not appropriate for a motion for new trial or new hearing based on the fact that they're re-arguing stuff that was already argued at trial. I could give you a pile of cases, if Your Honor would like, that stand for the proposition that A motion for rehearing or new trial should never be granted when a litigant is trying to relitigate issues and topics that have already come up at trial. That is exactly the case here. You know, counsel brings up these depositions. Your Honor, the depositions were set, and what happened is counsel requested dates for depositions of two parties, two non-parties. Counsel for the plaintiff provided numerous dates. Counsel selected two of those dates. The day before, I believe it was, of the depo, they realized that the date that they had selected was at Martin Luther King Jr. Day, which everyone else made themselves available for and said they would still be available for, but counsel the day before that deposition canceled the deposition. One of the depositions went forward. These are all dealing with, I shouldn't even have to get into this, but they're allegations of fraud. The deponent testified that she signed the document, that she had capacity to sign the document, and further that she had authority to sign this document. So there's really no issue related to that, and this was also argued at the trial. For purposes of the motion for rehearing under 1.530, it would be reversible error to grant their motion based on what they've presented to the court today.
Your Honor has two choices. Your Honor has two choices, obviously. Your Honor can rehear this matter if Your Honor feels that certain factual issues or certain legal issues were overlooked, or there was an erroneous decision made on them, and then Your Honor can send this back to the division judge for a ruling on the motion to strike. The motion to strike was not abandoned. If there's just no...
Well, yeah, but it was filed back in August of 2012. You had a hearing in December. You didn't get a really ruling.
Correct. If I may.
Yeah, sure. If you were interested in getting a ruling on it, you should have rescheduled.
But how can I get a ruling on it if I don't have the depositions, the evidence that I need to bring it in front of the judge? That was the key, Your Honor. The key to that motion.
For a motion to strike was filed before you had the depositions. I assume you had something to talk about.
All we had were documents that were signed by this individual, and then what Judge Schumacher says, listen, you need to go take the deposition of these individuals to find out if these are actually their signatures or not. It took us a year to do that. We went back and forth. This was not an easy task, Your Honor. The docket clearly shows that we engaged in active litigation to try to get these people's deposition. We finally got the deposition a week before the trial. We can't get a hearing on a motion to strike when there's a trial set. We went in front of Judge Schumacher and we said, Judge, there's a trial set for this matter on the 31st. Can you continue the trial? Because obviously we can't set this motion to strike before then. The judge said that's going to be a determination made.
Right, if I may just say one last thing.
I'm ready for the motion.
Thank you, Your Honor.